14 days lockdown due to COVID outbreak. We all got panicked when we heard this news. Why? We had sufficient groceries at our home. We were still living with our family. We were getting sufficient air and light from the outside world because there was no restriction as to using of windows, doors, etc. We had TV, mobile, internet for entertainment. We were still socializing with the outside world with the mode of calls, video calls, etc. We were getting news from the outside world in the form of news in YouTube or maybe TV news, etc. So we had everything except for getting socialized by going outside of our home. There are exceptions. Exceptions are exceptions. I have all due respect to those who have struggled during COVID lockdowns. But then the majority of world still was safe with sufficient food at home. Even then we all panicked because we couldn't socialize in the outside world. Why am I bringing this context here? Imagine you are put in a single room where there is no provision for sufficient light, maybe a small window which gives a ray of smallest hope with the form of very small amount of light. No socialization, nothing. You don't have electricity, you don't have phone, nothing in that room. And maybe 3 times in a day somebody is coming and just dropping the food from the smallest hole available in the below part of the door, and they just go off. What if that is the situation? Hey guys, welcome to my legal classes. This is Ganesh Pujari. In the series of Indian Penal Code, we were discussing chapter 3, which is all about punishments covered between section 53 to 75. And in that series, I am going to discuss two very important and sensitive sections, that is section 73 and 74. Here we are understanding solitary confinement. Most of the time we don't understand the seriousness of solitary confinement. That is why I use the context of lockdowns. If lockdowns were difficult, where there was certain restrictions for getting socialized, man being social animal has struggled a lot. And in this case, that is in solitary confinement, where there will be hardly any chances for socialization and not even sufficient light and air. In that situation, how life will be? Let's understand this serious topic with the help of my chart, my explanation, and maybe 5 important case laws. Not taking much of your time, let's get into the first slide. The term solitary confinement is not defined under IPC. In fact, in the Bare Act provision, I tried to find how many places solitary confinement is mentioned, and I could find 7 places, and all that 7 places are under section 73 and 74 of IPC. That way you cannot find much about solitary confinement in the Bare Act, but we cannot leave it there. Some or the other place we have to find some information about solitary confinement, and the right place to find anything about solitary confinement is the Mandela rules. Now the Mandela rules updated in the year 2015, and it defines the confinement of prisoner for 22 hours or more a day without meaningful human contact, that is considered as solitary confinement. And it also says that such solitary confinement shall be imposed in exceptional circumstances. Okay, it is not given at anything and everything. It is given only at exceptional circumstances. And if any solitary confinement is prolonged for more than 15 days, then it is also considered as torture. Okay, all of these information we are getting from Mandela rules. That is a very important information that we need to remember. Along with that, solitary confinement can also be called as isolation, lockdown, segregation, etc. If you ask me how can we define solitary confinement in a very simplest way, I have that here. This is a form of imprisonment distinguished by living in single cells with little or no meaningful contact with anyone. Okay, first thing first, we need to know that this is also one of the form of imprisonment. Secondly, Here the person will be kept in single cell all alone. Thirdly, he will hardly have any kind of contact with the outside world. That's why I have mentioned little or no meaningful contact. There is no opportunity for getting socialized. Okay, these are the three important aspects you need to remember. Or I have given one more line where I have mentioned solitary confinement is the physical isolation of individuals who are confined to their cells for most hours of the day. Now we have read Mandela rules. It says if it is more than 22 hours in a day, that is called solitary confinement. And here it is a physical isolation where a particular individual will be separated from outside world. He will be kept within four walls. That is what we need to understand. Now that's quite brutal punishment, and if it is so brutal, when is that used or why is that used? I have given few scenarios here. If the prisoner is dangerous for himself, or if he or she is dangerous for others, or if they have any contact with outside world and if they are not separated, there are chances that they continue to engage in illegal activities, or if such person is child molester, or in certain cases a witness is also kept in solitary confinement just to ensure that he or she is protected. Okay, it is also known as protective custody. And finally, punishment for violation of prison rules or other disciplinary infractions. Okay, these are the few chances where we see solitary confinement. I hope that is very clear. I've given all simple notes here. You can go through, and with that I am taking you to section number 73. Section 73 discusses about when and how much of solitary confinement can be granted, and I will quickly read through the barrack provision, which is quite lengthy, which says whenever any person is convicted of an offence for which under this code the court has power to sentence him to rigorous imprisonment, the court may by its sentence order that the offender shall be kept in solitary confinement for any portion or portions of the imprisonment to which he is sentenced, not exceeding 3 months in the whole according to the following scale. That is to say, a time not exceeding 1 month if the term of imprisonment shall not exceed 6 months, a time not exceeding 2 months if the term of imprisonment shall not exceed 6 months and shall not exceed 1 year, a time not exceeding 3 months if the term of imprisonment shall exceed 1 year. So here we are getting answers to two important questions: when and how much of solitary confinement can be given. Whenever the court can give rigorous imprisonment as one of the punishment, that is the first thing we need to understand. And how much if the imprisonment is below 6 months, then maximum of 1 month solitary confinement. If the imprisonment falls between 6 months to 12 months, that is above 6 months and below 1 year, in that case 2 months of solitary confinement, that's the maximum. And if the imprisonment is more than 1 year, in that case maximum of 3 months of solitary confinement can be given. So remember two very important things. One, the court which is awarding punishment has the right to give rigorous imprisonment. Remember, rigorous imprisonments can be given only in two scenarios. One, under IPC or any other law, it is very clearly mentioned that the imprisonment is rigorous imprisonment, or in certain sections it is mentioned imprisonment of either description. Okay, there if the court decides to go for rigorous imprisonment, only in such cases the court can order solitary confinement as per the below portion or portions. That is, if the imprisonment is below 6 months, then maximum of 1 month solitary confinement. If it falls between 6 months to 1 year, then maximum of 2 months solitary confinement. And if the imprisonment is more than 1 year, then maximum of 3 months of solitary confinement. So I hope that is very clear. In the next slide, we will understand more about this under section 74. There we are understanding more of it, and then we will move to case laws. Section 74 defines limit of solitary confinement, and the Bare Act provision says in executing a sentence of solitary confinement, such confinement shall in no case exceed 14 days at a time, with intervals between the periods of solitary confinement of not less duration than such period, and when the imprisonment awarded shall exceed 3 months, the solitary confinement shall not exceed 7 days in any one of the whole imprisonment awarded, with intervals between the period of solitary confinement of not less duration than such periods. The Bare Act provision is easy, and I am making it further easy with below charts. We will have two conditions here. One, when the imprisonment is equal to or less than 3 months, and the second scenario is when the imprisonment is more than 3 months. Of course, we are discussing about rigorous imprisonment. That is one another aspect you need to always remember, because that we have studied under section 73. Now let's shift to the first scenario, which is about the imprisonment is equal to or less than 3 months. Okay. Here what happens? The maximum solitary confinement for those offenders who got is equal to or less than 3 months of rigorous imprisonment. The maximum solitary confinement for them can be 1 month. And what is the maximum that can be given at a time? It is 14 days. Remember, under Mandela rules, it is 15 days, but in India, we already have maximum at 14 days, so we are good. The third thing, minimum break between two solitary confinements. Okay, one solitary confinement is given, the maximum days of solitary confinement is 14 days. If you again want to give another solitary confinement, in that case you have to give the same amount of break days between two solitary confinements. Like for example, it need not to be 14 days always. Remember or imagine you have given 10 days of solitary confinement. Okay, so before the next solitary confinement, at least there needs to be 10 days of break, because whatever solitary confinement you have already awarded, before you give one more solitary confinement, you need to give same amount of number of days gap. If you have given 14 days, then you cannot give solitary confinement again till another 14 days. If it is 1 day, there need to be 1 day break, and then you can give one more solitary confinement. I hope that makes it very clear. And to make it further clear, I have my next slide where I am explaining this concept with the help of illustrations. Now let's move to the second scenario. Here the imprisonment is for more than 3 months. Okay, rigorous imprisonment of more than 3 months. That is the case. Here I have 4 points. 1. The maximum solitary confinement for those offenders which are having more than 3 months of imprisonment, that we need to read with section 73. Now if it is below 6 months, then 1 month. If it is between 6 months to 1 year, then 2 months of solitary confinement. And if it is more than 1 year, it can be maximum of 3 months solitary confinement. That is what we understood from section 73. Coming back to the second point, maximum solitary confinement at one particular time is 7 days here. Okay, if the imprisonment is for 3 months or below, then what did we understood? It is 14 days at a time, but here maximum is 7 days at a time. And the third point, minimum break between two solitary confinements should not be less than the solitary confinement just finished, just like what we understood in the previous condition also. And in a month, maximum of 7 days solitary confinement can be given. This is one interesting additional point that we are seeing here, which we have not seen in the earlier portion. So we will have small confusion there, which I am going to discuss in the next slide. But I hope this is very clear as of now. And to make it further clear, I have my next slide where I have created illustrations to make it easy to understand. But as of now, in a nutshell, remember, if the imprisonment is equal to 3 months or below 3 months, then the maximum solitary confinement can be 1 month, and maximum at a time is 14 days. Minimum break between two solitary confinements should be not less than the solitary confinement just finished. Whereas if the imprisonment is for more than 3 months, then The maximum solitary confinement is as prescribed under section 73. Maximum solitary confinement at a time cannot be more than 7 days. The break between two solitary confinement should not be less than solitary confinement which is just been finished, and maximum solitary confinement days in a particular month is 7. I hope that is very clear. With that thinking, I am taking you to next slide where I have created few illustrations to make it easy. So I have created few illustrations. Let's imagine the first case where the punishment is equal to or below 3 months. I have two examples here. The first solitary confinement, for example, it starts from 1st January 2021 and the maximum allowed there is 14 days. Let's imagine 14 days solitary confinement is given. In that case, it can go up to 14 January 2021. So that is okay. And remember, the next solitary confinement should not be start anything before 29th January because you have already given 14 days solitary confinement. So you need to give minimum of 14 days gap. That is what you need to understand. But remember, mostly in the same month, there will not be more than 14 days of solitary confinement given. I have learned it somewhere, tried to do some research, could not find any reasonable legal answer for it. But as of my information, whatever my mind recollects, in a month, there will not be more than 14 days solitary confinement to any prisoner. If anyone finds it, you can just drop me a message. But let's moving on. In the second case, let us imagine solitary confinement of 5 days is given. That is from 1st January till 5th January. In that case, the next solitary confinement cannot be or shall not start before 11th January because here it was 5 days solitary confinement. You need to give 5 days break, that is 6th to 10th of January, and from 11th January you can start a fresh solitary confinement. I hope that is very clear. Here the overall solitary confinement cannot cross 1 month. That is the important aspect you need to remember. Along with that should be rigorous imprisonment. Now let's move to the second case. Here what happens, the imprisonment is for more than 3 months and I am taking the illustration where the rigorous imprisonment for 2 years. I am taking that illustration to make it all clear. In the first case, the solitary confinement was given from 1st January till 7th January 2021. In that case, he cannot be given any further solitary confinement in that month because the maximum in a month whenever the imprisonment is for more than 3 months is 7 days per month. So that is the first clause we need to remember. The second illustration, the solitary confinement was given for 5 days, that is starting from 27th January till 31st January. Here you cannot start another solitary confinement on 1st February thinking that that was different month and this is different month. No. If it was 5 days solitary confinement, it ends on 31st January and the next solitary confinement can start only on 6th February 2021 because the earlier was 5 days solitary confinement. You need to have minimum 5 days break. I hope that is very clear. And remember, this 27th January to 31st January is not connected with the first illustration. First illustration is over. You have given 7 days, that is over. Second illustration is a new case. If it was given between 27 to 31st, in that case, the new solitary confinement cannot start before 6th February because you need to give equal number of days of break in between. The third illustration, I am making it little more interesting. If the solitary confinement starts on 27 January and if it is of 7 days, in that case, it can stretch up to 2nd February. Okay, that is okay. You are giving one solitary confinement which starts in a particular month and ends in another month. That is okay. But in February, again, if you want to give solitary confinement, you cannot give it till 9th February because the previous solitary confinement was for 7 days. So you need to have 7 days break, and there what happens, your next solitary confinement can start only on 9th February, and the maximum solitary confinement again you can give in the month of February is 5 days because already 1st and 2nd of February he has served solitary confinement. So 2 days are over. So remaining 5 days can be given after 9th February 2021. I hope that is very clear. I cannot make it any further easy about this. I have worked a lot on this, and thinking that you guys have understood, I am moving to case laws. I think I said in the introduction that I am going to explain 5 case laws. My apologies there. I am going to explain 4 case laws along with one very important section from another law. That is the Prisons Act 1894 section 29, which discusses about solitary confinement. Now I will read out the barrack provision quickly, then I will explain a little bit on this particular section. It says, no cell shall be used for solitary confinement unless it is furnished with the means of enabling the prisoner to communicate at any time with an officer of the prison, and every prisoner so confined in a cell for more than 24 hours, whether as a punishment or otherwise, shall be visited at least once a day by the medical officer or medical subordinate. Here we need to observe 3 very important points. 1. There shall be provision for the prisoner to communicate to any of the officer of the prison. That is the first thing which the jail should confirm. Okay. The second thing is very interesting. The solitary confinement as punishment or otherwise. Now what is this? If a solitary confinement is ordered by the court as a punishment, that is called punishment. Okay. Like for example, the punishment is 6 months of rigorous imprisonment and court has ordered 10 days of solitary confinement. Now that is punishment. But what is this otherwise? Imagine Mr. X is a very dangerous person and he can cause the death of another inmate. Now the jail officers are worried, so that they are putting Mr. X in solitary confinement. Here there is no order. Okay. Here, just to protect another person, the jail officers have decided to put Mr. X under solitary confinement. Now the question is, can this happen? Yes, this can happen, but there are rules. In different case laws, Supreme Court has made guidelines that the jail officers shall inform this to the court within 2 days. But how many times that happens, that is a different question. But that is what you need to understand when we are using the term otherwise. Okay, I hope that is very clear. The last part, the third and last part is, there shall be a visit arranged. Okay, whenever it is going more than 24 hours, there shall be a visit from medical officer or medical subordinate. Now these are the 3 important conditions that you need to remember from the Prisons Act 1894 section 29. I hope that is very clear. With that, I am moving to the Sunil Batra case law. This case law, that is Sunil Batra versus Delhi administration, is one of the landmark judgment. Now the judgment is written by Justice Krishna Iyer, and this is one of the very important case law when it comes to solitary confinement. Now here, who is Sunil Batra? Sunil Batra was convicted for an offense and he was given death punishment as the punishment. And before he going through death punishment, one day he witnessed an incident. Okay, what happened? There was one more prisoner who was serving his life imprisonment, and this prisoner was approached by one of the jail officer and he asked money from this prisoner, and as the prisoner had no money or never agreed to give money, the jail officer got angry and he used his baton to pierce the anus of that particular prisoner. Okay, all of these incidents were witnessed by Sunil Batra. And what did Sunil Batra do? He wrote this incident to a judge of Supreme Court. Okay, now the court took a suo motu case, and in the judgment, Justice Krishna Iyer wrote that no solitary or punitive cell, no hard labor or dietary change as a painful additive, no other punishment or denial of privileges and amenities, no transfer to other prisons with penal consequences shall be imposed without judicial appraisal of the sessions judge, and where such intimation on account of emergency is difficult, such information shall be given within 2 days of the action. Conclusion: what we have stated and directed constitute the mandatory part of the judgment and shall be complied with by the state. Now, who decides the punishment? It is the court. What is the responsibility of the state or the jail authorities? Jail authorities have the liability to implement the punishment order or the judgment. Now, they cannot do more or less. Whatever is given as a punishment, that needs to be implemented, and no further violation of any fundamental rights etc. of the particular offender who is serving his punishment shall not be made by jail authorities themselves. And if they have to make some changes due to emergencies, as I explained in one of my earlier case, that is Mr. X case, there they have the liability to inform the judge within 2 days. That is what held here. This is a very, very important case law. That's why I told this is a landmark judgment, and Krishna Iyer wrote beautifully what is required and what is not to be done with the offenders who is serving punishment. It is one of the important aspects that we need to observe, that they do have their fundamental rights. Yes, there are limitations, but just because someone is going through punishment, that doesn't mean that they have lost every fundamental right. That is not the case. We'll understand more about that in few of the other case laws also. The class will continue. In between, I just wanted to share an important update with you guys. I have joined the Unacademy team as an educator for CLAT 2023 batch, and I would like to request you all to download the Unacademy app and follow me there also. And while buying the subscription over there, please buy the subscription with my code GYAN07, that is GAN07, to get additional 10% discount. And what's happening in Unacademy this week? My classes in Unacademy will continue, and a 1-year comprehensive batch for CLAT 2022 in the name of Laws KP starting on 10th November, and a 2-year comprehensive batch for CLAT 2023 in the name of Rankers Batch 2.0 starting from 12th November, and a beginners batch for CLAT 2023 in the name of Legal Issues is starting from 12th November, and a special class series to understand law entrance in India is happening between 8th November to 12th November. Please join them all, and while buying subscription, you can use the code GYAN07 for getting additional 10% discount. Thank you. This judgment is also wrote by Justice Krishna Iyer, that is Charles Shobraj versus the Superintendent of Central Jail Tihar. Now here, if you read the first line, prison justice implies court's continuing duty and authority to ensure that the judicial warrant which deprives a person of his life or liberty is not exceeded, subverted, or stultified. Now, the court has given punishment. The prison authority has the responsibility to implement that punishment and not go beyond that. If you read the judgment completely, there is very clear mention of Article 19, 21, 14, etc. And it was very clearly mentioned that the imprisonment or any other punishment should be done as according to the judgment order and not more than that. The authorities will not have any additional right to do any additional torture etc. That will not be considered as legal, and it is violation of the fundamental right under Article 19, 21, 14 etc., which is what discussed under this particular case law. Though in Sunil Batra's case, the Supreme Court very clearly spelled out that the jail officers shall not increase the severity of the punishment without the court order. There were umpteen number of scenarios where jail officers have done tortures or increased the severity of the punishment. That can be seen every time in the Indian prison history. So what happens there? To gain something from the prisoners or sometime just to prove themselves, there will be a lot of torture inside the jail. And if you know the case law from Tamil Nadu, Raja Kannu's habeas corpus case, there also there is a lot of reference on the torture in the jail to the prisoners as well as women, etc. We can see that reference. And considering all of these incidents, okay, Supreme Court has again and again told that jail authorities are the administrative part in implementing the punishment and they are not the court. Okay, they have to implement whatever court has said. Their responsibility is to implement the punishment and not to aggravate the punishment. But time and again the jail officers have done the same mistake, and which was again mentioned in Kishore Singh Ravinder Dev versus State of Rajasthan case law, where the Supreme Court held whenever there is aggravation of punishment, like for example imprisonment to solitary confinement, the jail authorities have to inform such information to the judges within 2 days, to the court within 2 days. That is what again held in Kishore Singh case law. I hope that is very clear. With that, I am moving to one of the very important High Court judgment in my last slide. This is a judgment from Uttarakhand High Court, but we need to give sufficient amount of respect to this judgment because this has covered a lot of aspects when it comes to solitary confinement. This is State of Uttarakhand versus Mehtab and Sushil. Now, the judgment is worth of reading, but I cannot go through the entire judgment. I have brought whatever is very important in this slide, and I cannot explain everything. But remember, earlier whenever death punishment was given, the person who was serving death punishment was kept in solitary confinement. Now that was understood by the court as two different punishment. One, the court has given him death punishment. Two, the jail authorities are keeping them under solitary confinement. It was not that nobody was aware, it was done in that way, but slowly the courts have started seeing it in a different way, and this 2014 judgment that very clearly mentions, okay, number 1 of 2014 and April 27 2018. Now this has two references and this is a 2018 judgment, and the one of the very important part of this judgment I have mentioned in last 3 lines, that says, according to the Supreme Court guidelines on various procedures before executing a death convict, solitary a single cell confinement prior to rejection of the mercy petition by the President is unconstitutional. It must be followed in letter and spirit. Okay, the court has already given him death punishment. Now he is waiting for death. In the meantime, if he has made some appeal or if he has put mercy petition, if the presidential pardon is in pending status, till the time that is been rejected, okay, there cannot be any solitary confinement. And recently lot of courts are also emphasizing that whenever death punishment is given, after all the procedures, there shall not be too much of delay between the declaration versus actually completing the death punishment, that is hang till death. There should not be too much of gap because that causes lot of psychological stress to the human being. That is what discussed in recent days also. But in a nutshell, in this case law, it was very clearly held that if a person is given or awarded with death punishment, till the time his pardon petition to the President is declined, he cannot be put in solitary confinement. He shall be treated like any other prisoner and left with all the other prisoners. That is what held in this particular case law, which came in the year 2018 judgment. I hope that makes a lot of sense, and with that I am handing over this presentation to Nishan.
With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye.